Okay, this is about deprivation of rights, where it starts. And I was in some of my videos that I showed you, it was actually of other people going over conspiracy against rights under the color of law and stating so in court. You seen that one Latino guy telling the judge, do your job, cite my attorney for ineffective assistance of counsel, etc., etc. And I was explaining I try to explain that, but there's a lot of laws they don't understand. It's behind the oath. First of all, everybody's violating the oath. Penalties for violating an oath. Look up that. They have their oath of office, judges, lawyers, politicians, but there's also the oath of public service. So they're also violating the oath of public service. You should read that. That has more detail. Okay, but I explained to him before anything can proceed in the court of law, you must give informed consent. And this tells you penalties for a lawyer's failure to get informed consent. That was what I put in the search bar. Penalty for a lawyer failure to get informed consent. I did a video on this once or twice. I really don't remember exactly. I really don't watch my videos. I know what I said. And all I do is cite a lot of laws. Okay, word for word to the letter. As you well know, as I mentioned in one of my other videos, penalties for violating the letter of the law are stiff and stern. Fines, removal from public service, and incarceration, and a death is involved in violating the letter of the law. Those people can get the death penalty. Okay, a lawyer's failure to obtain client consent, particularly for major decisions like settlements, can lead to severe penalties, including professional discipline by a state or bar association and legal malpractice lawsuit by the client. So, you can get any lawyer for that. Professional discipline. State bar associations enforce the rules of professional conduct. And that's what that guy was telling the judge. This guy violated rules of professional conduct. I didn't know nothing about it. I just found out about it. So everything that happened, he even mentioned, violating a quick and speedy trial. That happens to everybody. But it's rarely a judge will toss it out because, if you're denied a quick and speedy trial, there are limitations on that. Okay, look up a quick and speedy trial. And whatever state you're in, it'll tell you what your rights are to a quick and speedy trial. And in Illinois, I think it's 90 days if you're incarcerated, 120 days if you're out on bond. You have a right to a quick and speedy trial. If it doesn't happen within that time frame, then the case is dismissed. You can ask for it to be dismissed with prejudice for that lack of a quick and speedy trial. And they can't bring it up again. I think I mentioned that in one of my other videos. There's a lot of things you don't know that's behind that oath. Okay, so I'm giving you a lot of stuff that, all our public servants are supposed to be doing that nobody's doing. So, seriously, just sticking to one video, you should check them all out, and pick and choose which ones you want to use in your case, whether state, federal, civil, criminal, child court, divorce, housing, no matter what it is. Okay, you're going to need the rules of professional conduct and the code of judicial conduct in order to obtain due process or some remnants of it, as close as you'll ever get to a fair trial. And it's the only way you're going to get near having effective assistance of counsel. And without abiding by the rules and the codes, you lack effective assistance of counsel, which is intentional because everybody knows the rules and the codes are laws within a court of law. Those are laws. And to knowingly and willingly violate those codes and laws, that's not just ineffective assistance of counsel, that's defective assistance of counsel, that's destructive assistance of counsel. So that's not only decimating and desecrating on the oath they took to the U.S. Constitution, but defecating on it as well. Okay, so they're literally violating the oath as well as numerous other laws that are stated in the Rules of Professional Conduct and the Code of Judicial Conduct. The State Bar Association enforced the Rules of Professional Conduct, which require lawyers to obtain informed consent from any acts, especially those affecting a client's substantive rights, e.g., settlement offers, waiving claims. Who waives a claim to a quick and speedy trial? Nobody. Or certain conflicts of interest, penalties imposed by the disciplinary report or the court can include disbarment, permanent revocation of lawyer's license to practice law, most severe sanction. Once you cite all the violations in the rules and the codes, thus the conspiracy against rights under the color of law, everybody's getting disbarred. Okay, suspension, a temporary loss of the ability to practice law, often for a fixed period of time, up to several years. Probation, the lawyer is permitted to practice under supervision and must comply with specific conditions. Reprimand, admonishment, a formal or public private rebuke for the minor misconduct. It is no minor misconduct when you lose your kids, your house, when you're old and you get stuck in guardianship just because you're old. People in probate court, most of them don't know what's going on. Where along the lines did you give informed consent? In order to give informed consent, one needs reasonable knowledge to make an informed decision to give informed consent, and that's in the Rules of Professional Conduct in the preamble. That is law. The severity of the discipline depends on factors such as intent of the lawyer's intentional versus negligent, the harm caused to the client, and any aggravating or mitigating factors. It's always intentional. You cannot violate the rules of professional conduct without violating the Code of Judicial Conduct, because it's mandatory to report misconduct in the rules of professional conduct and the Code of Judicial Conduct. Any violations of the rules of misconduct is misconduct. Failure to report misconduct is misconduct. In the Code of Judicial Conduct, it's mandatory to report any misconduct by the attorneys. Failure to do so is misconduct. Judge violating the Code of Judicial Conduct, it's the attorney's legal obligation to report that judge or any attorneys for any misconduct, violating the rules. Everybody's violating the rules and codes, so everybody's supposed to be reporting each other. Nobody's doing it. Thus, you have the conspiracy against rights under the color of law. Each is guilty for deprivation of rights as well as a conspiracy against rights under the color of law. Look up penalties for each. You will be amazed. Legal malpractice lawsuit. A client who has suffered damages because their lawyer acted without informed consent can sue the lawyer for legal malpractice. To succeed, the client generally must prove attorney-client relationship existed, duty of care owned. Okay, so when the lawyer takes on your case, he's to treat your case as if it's his own, her own life, liberty, pursuit of happiness that's at stake. Did they do that? It's in the preamble of the Rules of Professional Conduct, folks, okay? I would read the whole thing to you. Last time I made a video on that, going over the whole thing, took about 2.5 hours, a little more. And to be honest with you, I don't think most of you sit through more than 10 minutes of my videos. And some of them are up to an hour long. Some of them are a minute and a half, 2 minutes, 3 minutes, 15 minutes, 20 minutes. They're all depending on the issue at hand, but there's many laws you can use that are being broken. Remember, when it comes to the Constitution was written to protect, serve we, the people. Okay, these are not just your constitutional rights, your civil rights. These aren't just the Bill of Rights. People, these are your birthrights as a United States citizen. A client who suffered severe damages because their lawyer acted without informed consent can sue the lawyer for legal malpractice. To succeed, the client must prove attorney that there was a contract between you. The attorney breached that duty, violating the rules of professional conduct. That's easy to prove just going over the rules because they can't prove they did any of that, thus proving guilt. The client suffered damages. That's easy for you to prove. The damages were a direct result of the attorney's actions. I had a lawsuit for workman's comp, and the lawyer decided to settle without my consent, knowledge, and then quit when I rejected that. And then I had to appear in court myself. And the judge started citing me for violating the rules, but not actually citing. He would say that how long it took and, the time and the inadequate filings and, basically I was violating all the rules of professional conduct, but he did not cite the lawyer that was handling the case on either or side or itself for violating the code of judicial conduct. And before I could say anything, I was escorted out of the court, which is entirely ridiculous. If the lawyer settled the case for less than it was worth without consent, the client may be able to recover the difference as damage. The client may also be able to recover punitive damages in the case of egregious misconduct. Other consequences: forgeries or criminal charges. If the lawyer forged the client's signature on settlement documents or engaged in dishonest acts, they could face criminal charges in addition to disciplinary action. Withdrawal. The lawyer may be required to withdraw from representation if a conflict of interest arises and that cannot be resolved with informed consent. Loss of client's reputation. A breach of trust serially damages the lawyer's reputation, can lead to a loss of current and future clients. This is especially essential for my guy, John James. Intelligent guy. I don't think I went over this with him thoroughly enough, but he can do it himself, so I'm going to leave this on his wall. In essence, a lawyer acting without client consent is a profound ethical and legal breach with serious consequences that can jeopardize their career and result in financial liability. Can a lawyer settle without my consent? No. What is the most common complaint? Well, what commoners, as they call us, laymen, people that don't have a legal degree, they'll tell you about the most common complaint, but what they won't tell you about, all the violations and the rules of professional conduct, the judge not citing your lawyer for violating those rules of judicial misconduct, the opposing party not citing your lawyer or judge, that's misconduct. Failure to report misconduct is misconduct. Expediting litigation, fairness to the opposing party, diligence, communication, candor towards a tribunal. Those are laws, people. Those are just common words to you. But, lots of times when I use them talking to lawyers, they would get mad and walk away. Or when they would try to explain a law to somebody, sometimes I would just be a smartass. You know what penalties are for violating the letter of the law? You know what those are? And I used to have copies of a lot of stuff. When I was younger, people used to call me a hoarder, but the only thing I was hoarding were copies of laws. I couldn't afford the books, and I didn't need the whole book. I just needed the foundations, the essentials. What's supposed to happen in every court of law. The legal obligations of all lawyers and judges. Most common complaint against lawyers is inadequate communication, which communication is mandatory. That's the law. if you read the rules of professional conduct, which includes a lack of responsiveness to phone calls, emails, not providing case updates, and failing to explain what is happening in the case. Other frequent complaints involve neglect, issues with billing or excessive fees, and dishonesty and misrepresentation. Dishonesty that's usually through disinformation. Disinformation is illegal. Communication is mandatory. So lack of communication is illegal. So when you look up the rules of professional conduct, also type in rules of professional conduct complaint form. Okay, because that's when you're going to apply all this with your state bar or, whatever disciplinary board. And the same thing with the judges. Look up Code of Judicial Conduct Complaint Form. Code of Judicial Conduct and Code of Judicial Conduct Complaint Form. And then read that shit. If you're on a computer, download it, highlight every issue. It didn't happen, and you'll find plenty. There's a lot of laws that are broken that you just don't know about. And I'm just showing it to you. I'm just showing you a whole bunch of laws, okay? What is the most serious disciplinary sanction imposed on a lawyer? The most serious disciplinary action imposed on a lawyer is disbarment. As far as what they do. But see, if you bring up all these laws they broke, first of all, violating the oath of office, they take as a lawyer, the oath of public service, deprivation of rights. You have, they are required to get informed consent from you. They don't. And that's required in the rule of professional conduct. And the rule of professional conduct, in essence, is what gives you effective assistance of counsel guaranteed in the Sixth Amendment of the U.S. Constitution. Lack of effective assistance of counsel is a lack of a fair trial. Lack of a fair trial is a lack of due process. That's deprivation of rights. Can a lawyer settle without my consent? No, I know that. I mean, it's common sense. I was explaining I used to call everybody John, short for John Q. Public, a term that was used when I was young, back in the 60s, 70s, a long time ago, or average Joe. But I like to use terms average Joe and average Joanne. Women are equally as important in our society as men are. So when it comes to we the people, that's all I see. People say they don't see color. When I see my neighbors, that's what I see. We the people. I walk out that door. I treat them as I want to be treated. Respect given is respect earned. Equally can be said for the contrary. Okay, so, violating the rules of profession, violating any laws, not doing what's required by the rules of professional conduct. Those are also ethical violations. So you can, where to file ethics complaint, just type that in your search bar. Okay, dive deeper into AI mode. Lawyer who fails to obtain required client consent faces severe penalties, which can include professional discipline, admonishment, reprimand, suspension, or disbarment, legal malpractice lawsuits, some cases criminal charges. Professional discipline lawyers are bound by state-specific rules of professional conduct based on the ABA model rules. And as I told you before, I've had lawyers lie about it. When I brought up the model rules, they go, oh, no, that's not like for my state, that's the model. I said, yeah, which is a state where the model rules is for every state. They take that and they can build on it, they can add to it, they can't take from it. Taking from it is essentially in the interest of the bar, and it quite simply says in the preamble, they can only do what's in the public interest, not in the interest of the bar, self-interest, parochial interest. Okay, so lawyers are bound by specific rules of professional conduct based on the ABA model rules of failure to get informed consent for specific actions such as settling case, revealing confidential information, or managing conflicts of interest is a serious ethical breach. Disciplinary actions are determined by the state or bar association or the high court and depend on the severity of misconduct, the lawyer's intent, and the harm caused by the client or to the client. Penalties can range from admonishment to reprimand, probation, suspension, disbarment, legal malpractice, lawsuits. So people, if you're going to hit them with a legal malpractice lawsuit, cite all the violations in the rules and the codes. And don't just go after the lawyer, go after the opposing party, because they didn't cite your lawyer, which is violating. They're literally depriving you of rights. They assisted your lawyer in depriving you your right of effective assistance of counsel. Effective assistance of counsel guaranteed in the United States Constitution. Sixth Amendment guarantees every lawyer, as well as judges, will abide by, enforce the rules and the codes. Okay, the client suffered damages as a result. Okay, if a client is successful, the lawyer can be held personally liable for the client's losses. The lawyers may also be compelled to return legal fees. And I've had that happen for a couple people. I got this guy out of Centralia prison in '91 based on a conspiracy against rights under the color of law. I cited the judge for not citing his lawyer, for violating the rules and the codes, the opposing party for not citing his lawyer for violating the rules and codes. Thus, citing them for misconduct, for their failure to report misconduct. And then I started citing the rules that the opposing party broke by not citing that misconduct, the codes, the judge. And I didn't have any evidence. They didn't give him anything. He didn't have discovery or anything. All I had were the rules and the codes, and I explained how everybody broke them, thus depriving him deprivation of rights I mentioned the privation of rights by all attorneys involved and the judge, and nobody citing each other and dismissing his case with prejudice. It's conspiracy against rights. But anyways, it was on a late notice of appeal. His lawyer didn't file his appeal, kept the money, $7,500, and that was, his wife was going to lose the house. She was all worried. She was crying. I seen him kind of with a couple tears, and this kid there, and I felt sorry for him. So why don't you just file a late notice of appeal? He didn't know what the hell I was talking about, so I just wrote it up for him. Told him, take it to the library, have it notarized. Don't sign it till you get there. No, have it notarized, sign it there. I should make like about 10 copies, give them to everybody you could trust, have them read it, simple English, and he was in prison. He got out of prison like 2 weeks later. They expedited that litigation because I used the rules. I said, and in their judgments, I believe it would be diligent to expedite this litigation. It would be a great show of competence. And I threw I threw the rules at him, So they expedited that litigation. The guy was out like 2 weeks later. I never heard from him again. He got the money back. He told me so his wife was able to, and they took out a loan or something, for the house, and it was a guilt by association thing, He was out, went to get something on this weekend, early motorcycle ride, stopped at a bodega, said hello, shook some guy's hand, jumped on his motorcycle, and I don't know if he was on his way home, but he said after he left, he got pulled over. And potential criminal charges in extreme cases of a lawyer acts without consent in a matter that involves illegal acts. They may face criminal charges, for example, forging a client's signature, settlement check released from its crime, unauthorized disclosure of certain highly sensitive information. Could also lead to criminal penalties, other consequences, case dismissed or loss of rights. A lawyer's actions without proper consent, e.g. missing deadlines or mishandling a settlement, could lead to the client's case being dismissed or the loss of their legal rights, which in turn strengthens a malpractice claim against the lawyer. Damage to reputation, professional misconduct can prematurely damage a lawyer's reputation in the legal community. Court sanctions a judge may impose fines or other sanctions during the case if a lawyer has acted improperly without authority. What actions require specific client consent from a lawyer? How does a lawyer discipline vary by state? What are some examples of legal malpractice cases? Just violating the rules of professional conduct, people. Your lawyer violating the rules of professional conduct says it all. And it's impossible to violate one rule. It's impossible. You violate one rule, you violate multiple rules. You violate any rule, you're violating anything and everything that's said in the preamble and or in the scope. You can use anything and everything in there against them. That's a whole lot of ammunition. So before you start throwing out what you lost, before you start complaining about everything you went through when you lost, first start what was supposed to happen in the beginning. And that starts with informed consent, okay? And no way in hell did you get it if you weren't made aware that you were supposed to have informed consent. You weren't aware that was a legal responsibility of the court, not just your lawyer, but of the court itself. Okay, because remember, this stands for all lawyers. Say, well, he's not a lawyer, he's a judge. Well, a judge is required to be a lawyer in order to be a judge, so they need that license, and that license revoked, they can't be a judge, and, come on, people. Let logic be your guide. If it's not logical, it's illegal. Okay, so remember, start with informed consent. Okay. That's where your deprivation of rights starts, with your own attorney. And the only way you can say, I can't tell, because everybody I talk to, nobody's ever been, it's always been new. Everything I talk about is always new to them. Nothing ever spoken to them about, to their lawyers. And I've been doing this since 1979. But see, a lot of people didn't believe me. I guess because I was young. They used to call me the long-haired friend of Jesus. I used to preach, but kind of sucked at that. But I still do the Lord's work, but just in a different way. Just in a different way. Being informative. And for the eyes that I open, the minds absorb what I talk about, what I show you, and use it. I feel blessed. It's a blessing to me when any of you take what I've learned throughout my years and use it for yourself. I'm doing my best to teach you to be the hero in your own story. Okay, so let's start with deprivation of rights. The lack of informed consent, the lack of the knowledge of of all lawyers and judges' legal responsibilities to you in any court of law. You know, the rules, the codes. Knowing that is the start of informed consent. Informed consent, the legal requirements are to have the reasonable knowledge to make an informed decision, to give informed consent, and it says so. And the preamble, the rules of professional conduct, people, you can find it in the ABA preamble, rules of professional conduct. And if it's not, and when you look in your state, if it's not there, just put it there. Hey, you're the public, it's in your interest. It not being there is in the interest of the bar, which is illegal. Okay, nothing but peace and love to you, folks. May your Creator always be with you and rain many blessings. Here's to your long life and good health.